Today we are going to discussing about Devadassan versus the second class executive magistrate. When we begin to analyze the findings of Honorable Court, the Honorable Apex Court observed that there were 8 criminal cases registered against the appellant, including simple and grievous hurt, theft, and also under the Arms Act. So, after the report from second respondent, a shock cause notice was issued to the appellant and inquiry was conducted by the first respondent. In furtherance of its statement was recorded and response had also been taken. So the first respondent recorded the satisfaction the appellant might cause a breach of peace of locality, however, directed him to furnish a bond to sum of rupees 50,000 without surety for a period of 1 year under section 117 of CRPC. Filing the same, the appellant may serve imprisonment under section 122 clause A of CRPC or a breach of conditions because of section 122 clause B of CRPC may be taken. Section 122 clause B, which provides that imprisonment in default of security. So, after the execution of bond on 31st March 2021, it was registered joining the appellant as a accused for offence of murder at police station at Ramanathapuram and breached the terms and conditions of the bond. So, a shock cause notice was issued asking the response and also sought appearance of appellant before the first respondent on 7th May 2021. So the appellant submitted its explanation and its statement was recorded. So the first respondent affording the opportunity passed the order on 13th May 2021, holding the appellant guilty for violation of terms and conditions of bond and punished under section 122 clause 1 clause B of CRPC. In pursuance of order, is arrested and sent to the prison, which is provided in paragraph 7. And chapter 8 of CRPC, which confers to the executive magistrate to take a bond for maintaining security and for keeping the peace and good behavior by the citizens. As per section 107 of CRPC, on receiving information that any person is likely to commit a breach of peace or disturb the public tranquility or to do any wrongful act, the executive magistrate may have a power to show cause on violation of terms of a bond so executed for maintaining peace. As per section 108 of CRPC, similar powers has been given for maintaining the security for good behavior from the persons disseminating seditious matters. Similarly, to take a security for good behavior from suspected persons and habitual offenders, powers under section 109 and 110 CRPC have also been conferred upon executive magistrate. It is also provided in paragraph 7. So here the Honorable Supreme Court held that in the present case, the order was passed under section 111 and 117 CRPC for security on violation recourse specified under section 122 CRPC is permissible. Therefore, the legislature introduced the said chapter conferring powers on authorities to take action for violation of peace and tranquility in public order by citizen of locality. Otherwise, by following the procedure as prescribed, the action may be taken by the competent authority. The court also observed that nothing was brought on record show a non-compliance of Chapter 8 of CRPC, and it is a tried law that by following the procedure established by law, the personal liberty of citizens can be dealt with. So the bond executed by the appellant has been violated by him on account of its involvement in criminal case, and the registered subsequently and bond executed has not been questioned. So the impunged order of first respondent sending the appellant to the custody has been assailed, and the Honorable Court held that the order passed by the first respondent is after following the procedure, so prescribed and affording due to opportunity of the appellant. Here the High Court has rightly affirmed the said order, which is provided in paragraph 8.
In the case of Devadassan versus a second-class executive magistrate, the appellant executed a bond to maintain good behavior and peace for a period of 1 year and also undertook to pay rupees 50,000 as penalty to the government in case of breach or else face the proceedings under section 122, subsection 1, clause B of CRPC. Even on the execution of bond, he was found involved in the commission of a murder. The executive magistrate and the High Court found the appellant guilty for breach of the conditions of bond and punished him under section 122, subsection 1, clause B of CRPC. Thus, the present appeal has been filed by the appellant in the Supreme Court. A. Lakshmi Narayanan, the Law Counsel appearing for the appellant, argued that the administrative authorities usually do not follow the procedure prescribed and afford reasonable opportunity. He relied upon a few important cases in this regard. The first one is Aldenish versus State of NCT of Delhi, where guidelines were issued to impart the training of these officers. The second one is Devi versus Executive Magistrate. The third one is Premchand versus Union of India, which specifies the manner in which the police personnel must act upon. And the fourth one is Gopalan Achari versus State of Kerala, in which the importance of Article 21 of the Constitution is pointed out. Dr. Joseph Aristotle, as the Law Counsel representing the respondents, argued that 8 criminal cases were pending against the appellant. That is the reason why bond was taken under Section 117 of CRPC, asking for security. On violation of the said bond, the order under Section 122, subsection 1, clause B of CRPC was passed against the appellant. Later, the appellant was found involved in the commission of a murder and a show cause notice was issued. In reply filed by the appellant, execution of the bond was not disputed, and making him accused in the murder case was also not denied. Before moving on to the judgment, I would like to emphasize on some of the important sections in this case. First of all, the executive magistrate is a person who mainly focuses on the police and the administrative functions with little or no concern about the judicial aspect of the process. And Chapter 8 of CRPC confers the powers to the executive magistrate to take bond for maintaining security and for keeping the peace and good behavior by the citizens. As per Section 107 of CRPC, on receiving the information that any person is likely to commit a breach of peace, disturb the public tranquility, or do any wrongful act, the executive magistrate may have power to show cause on violation of the terms of bond, so executed for maintaining peace. As per Section 108 of CRPC, power has been given for security against persons disseminating seditious matters. And under Section 109 and 111 of CRPC, similar powers have been conferred upon the executive magistrate for suspected persons and habitual offenders. In the present case, the order was passed under Section 111 and 117 of CRPC for security. Section 111 of CRPC deals with the order to be made. When a magistrate acting under Section 107, 108, 109, and 110 deems it necessary to require any person to show cause, he shall make an order in writing, setting forth the substance of the information received, the amount of the bond to be executed, the term for which it is to be enforced, and the number, character, and class of sureties, if any, required. Section 117 of CRPC is the order to give security. If upon an inquiry it is proved that it is necessary for keeping the peace or maintaining good behavior, the person on whom the inquiry is made should execute a bond with or without sureties, and the magistrate shall make an order accordingly. Also, Proviso 3 of Section 117 of CRPC says that when the person in respect of whom the inquiry is made is a minor, the bond shall be executed only by his sureties. And Section 122 of CRPC deals with the imprisonment in default of security. Therefore, the Supreme Court in this case held that the Law Counsel for the appellant, by referring to the case of Aldenish and Devi, could not prove that in what manner the procedure contemplated under Chapter 8 of CRPC has not been followed. Also, in response to the case of Gopalan Achari, where Article 21 was referred to, the court said that it is a tried law, that by following the procedure established by law, the personal liberty of the citizens can be dealt with. Here, the bond executed by the appellant under Section 110, read with Section 117 of CRPC, has been violated by him on account of his involvement in a criminal case, and the bond executed by the appellant was also not questioned. Therefore, the order passed by the executive magistrate is after following the procedure so prescribed and affording due opportunity to the appellant. The High Court has rightly affirmed the said order, and so the appeal was dismissed by the Supreme Court. Thank you.